Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's case, we've got a case of qualified immunity and a little Bivens action in Police versus Police. This is the story of United States Secret Service versus United States Park Police. In this case, the United States Secret Service agent, Mr. Hicks, was sitting by the side of the road in his government-issued Secret Service car that looks very much like a police car, because it was. And the Park Police decided to initiate a stop. And then things got really weird. And things went on for a long time. So Mr. Hicks, the Secret Service, is suing the Park Police for deprivation of civil rights. Who will win? In the case of Secret Service versus Park Police, let's get started with this. In the early morning hours of July the 11th of 2015, Nathaniel Hicks, then an agent of United States Secret Service, was parked on the shoulder of Interstate 295 North in Maryland, waiting to lead an oncoming motorcade in his government-assigned vehicle, which had police antenna, strobing bar, and illuminated emergency lights. So, looks very suspiciously like a police car. At approximately 6 in the morning, Gerald Ferreira over here, who has a bug up his butt, as we're going to see, who is an officer with the United States Park Police, parked his cruiser behind that of Hicks's government vehicle and approached, initiating what would become the first of two stops of Hicks, this one lasting for between 40 and 60 minutes. Okay? So, yeah. So, the Secret Service guy is in his police car getting ready to be part of a motorcade. So, this is procedure. Like, they have this whole, cars come in, cars come out. So he's at the head of the line, so maybe he can block traffic or whatever else he's doing. So this seems very routine as part of a motorcade. And the Park Police comes up beside him, and they want to initiate a stop, and they're suspicious. And the stop lasts for 40 to 60 minutes. The first stop. What was the nature of this suspicion? Why do the Park Police have such a huge bug up their butt? Let's read some more. As the Park Police officer approached, Ferreira saw Hicks's service weapon, a handgun, inside the car and drew his own weapon, which I guess is kind of rational. Hicks quickly identified himself to Ferreira as a Secret Service agent and displayed his credentials, including a photograph of himself and a description of his mission. Ferreira seized his service weapon and credentials and took them back to his police cruiser for verification. Ferreira since acknowledged that credentials looked legit and he had no reason to doubt their validity. Okay. So far things are a little bit weird because things look pretty legit. And a fake cop car usually is not that great in detail. They don't normally fool you from any sort of up-close inspection. So maybe this guy thinks it's a fake cop car, I guess. But when you're getting close and you see, for example, the government-issued tags on the car, right? And it looks very formally like a police car, right? And you say, you see his gun, and then he says, here are my credentials. And here's what I'm doing. Maybe it's legitimate. And maybe you should just be like, sorry for the mix-up. Get a good laugh out of that. Is there anything I can do to help, maybe? There's a little bit of offering to mend fences. Maybe I can help in some way. And live that Secret Service life for just a moment. But no, this guy decides to doubt him despite the authentic car and the authentic credentials. And this guy... just nothing makes any sense. Okay, let's read some more. Despite fully satisfying himself that Hicks was, in fact, a Secret Service agent who was authorized to carry a handgun under both state and federal statutes, which Ferreira continued detaining Hicks while calling for additional officers to report to the scene. Next to arrive was Brian Phillips, also an officer with the United States Park Police. Although Phillips too soon learned that Hicks was a Secret Service agent, Phillips assisted Hicks' continued detention while Ferreira called for a third officer, this time a supervisor, to come to the scene as well. Okay. Ferreira has since confirmed they had no intention of arresting Hicks when calling the supervisor, but Ferreira and Phillips continued to detain Hicks and maintain possession of the service weapon and credentials. By now, the motorcade that Hicks had been assigned to lead had come and gone. So, this is kind of weird. The Park Police apparently really, really want to flex that Park Police jurisdiction, yo. So I can't deny the fact that the Park Police have primary jurisdiction in this situation over the Secret Service. especially because they're not like actively guarding somebody. So in this particular factual scenario, the park police have primary jurisdiction. That being said, however, like, what is going on here? The first guy comes up, takes his service weapon and badge, verifies him, then calls a second guy, verifies him, calls a third guy, and they had no intention to arrest him. We're just detaining him because we want to flex. I'm not sure why we want to flex. I'm not sure why we feel it necessary to flex, but apparently we feel it very necessary to flex. I don't know why. It doesn't make any sense. But that would not be the end of it, because as I mentioned before, that was the first of 2 stops. Let's read more. After the motorcade had passed, the United States Park Police supervisor arrives and informed Hicks that he was free to leave. And Ferreira returned the weapon and credentials and allowed him to leave. By then, it was between 6:40 and 6:59, or 40 to 60 minutes after the stop was initiated. And by no later than 6:25 a.m., and perhaps much earlier, the park police over here were fully aware it was an on-duty Secret Service agent authorized to carry a weapon, but nevertheless continued the detention, which leads us to the second stop. The second stop at issue occurred minutes later, when Hicks, almost as soon as he left the scene of his initial detention, was pulled over by Phillips, one of the guys who was there just minutes ago. So as he's driving away from the scene, as he's finally been released, he's pulled over for a second time by the same guy. Okay. Hicks was not driving erratically, and Phillips knew it was the agent vehicle he's stopping. Phillips approached Hicks' vehicle and said, "I noticed when you departed the scene you were on the phone. It's against the law in the state of Maryland for an officer to be on the phone while driving." And then the court notes parenthetically, in fact, Maryland law expressly permits law enforcement officers like Hicks to use their cell phone off while driving. Yeah. Although Phillips concedes that he recognized Hicks when he approached the car, he nevertheless demanded license and registration to detain him further before ultimately detaining him. Okay, this is great. So this guy gets pulled over for using a cell phone, but he's allowed to because he's a police officer. And who might he be calling? I don't know. Some of his buddies in the Secret Service about, here's why I didn't leave the motorcade and all. Might want to check in with his supervisor maybe. And now he's getting pulled over for using a cell phone. And even though it was Phillips who had pulled him over or been part of pulling him over minutes ago, we're like license and registration. You know for an absolute fact who I am. You know for an absolute fact what car this is. What are you doing, man? I don't know. The park police really have a bug up their butt that day. In July of 2016, Agent Hicks filed a Bivens action for damages against the officers, alleging the officers had violated his clearly established Fourth Amendment rights by unlawfully seizing him twice without probable cause or reasonable suspicion. Yeah, even reasonable articulable suspicions looking a little shaky. It's a low standard. It's low. But, man, this is below that. The officers ultimately moved for summary judgment on the Fourth Amendment claim, arguing that they're entitled to qualified immunity, which is always a good place to go. With respect to the first stop, the court started by clarifying the nature of Hicks' claim. Hicks did not challenge the initiation of the first stop when Ferreira observed the car and then his service weapon. Instead, Hicks invoked the well-settled doctrine that a seizure that is lawful at its inception may become constitutionally unreasonable if it lasts longer than is necessary to effectuate the purpose. According to Hicks, his stop, which lasted for up to an hour, became constitutionally unreasonable once the officers had determined he was an on-duty Secret Service agent authorized to carry his weapon, thus dispelling any reasonable suspicion and effectuating the purpose of the stop. So he argues, properly, that they can probably get to reasonable articulable suspicion at the front end. Because maybe it's a fake car, maybe it's a fake cop car. Maybe it's a really, really good fake. Really good fake cop car. I don't know, man. I've never seen a cop car that's that good, but okay, a fake one. I've never seen the one that's that good, but let's go with that. So he was reasonable at that time. He was reasonable to take his credentials and firearm as part of a standard step. But something that is legal at one point may become illegal at some later point. And that can also work the other way around. Something that's illegal can become legal, right? Because facts change. And so his argument is, yeah, at some point along the way, it became illegal. When would that point be? Well, the point of the stop was to make sure, I guess presumably you thought I was a fake cop car. And once you verify me, you know I'm not fake. So that would terminate the purpose. So after that, it would become illegal because you had no new suspicion. You didn't develop new suspicion along the way. It's not like you observed something new that gave you new cause. No, you had nothing new. You just decided to keep going. You can't do that. Yeah. Phillips also cited Hicks' use of a cell phone as to justify the stop. But the district court went on to find that once Phillips recognized Hicks as the same secret officer he had just detained, coincidentally, no later than when Phillips approached Hicks in his car, he had no basis to suspect Hicks of violating Maryland's prohibition on the use of cell phones while driving, which clearly does not apply to on-duty law enforcement officers or continue to detain Hicks while demanding his license and registration. None of this makes any sense. Before turning to the question of qualified immunity, the court must consider the officer's late-breaking argument that Hicks' constitutional claim should have been dismissed at the outset because he lacks a cause of action under Bivens. In Bivens, the Supreme Court recognized an implied cause of action for certain damages suits against federal officials who violate constitutional rights. In that particular case, against federal law enforcement officers who allegedly violated the Fourth Amendment through a warrantless search and arrest and the use of unreasonable search. Since the court has decided that Bivens case, however, the court has disfavored any expansion of Bivens and has refused to extend Bivens to any new context or new category of defendants. So the U.S. Supreme Court had this case called Bivens, which is essentially equivalent to 1983 cause of action for a federal officer. So where you can go after a state level official for 1983, Bivens is your cause of action in federal court. However, Bivens is much more narrow. As difficult as that might believe, it's much more narrow than 1983. Because we go through 1983 all the time and there's many, many exceptions. So you might think it's pretty narrow. I assure you Bivens is even narrower still. It doesn't apply in very many contexts because the Supreme Court has basically constantly refused to expand it beyond its own terms. So they said, yeah, there's an implied cause of action and there's like, never bring it up ever again. And so they are saying, the people that are defending this are saying, well, this is a new context, so it's not Bivens, which might be a reasonable argument in the abstract. What made it not reasonable in this case? Let's read some more. Here, the officers argue their case, notwithstanding similarities to Bivens, which likewise involved a Fourth Amendment claim against federal law enforcement officers. This presents a new Bivens context, and that allowing it to proceed would run afoul of a later case called Abeas, which basically put the door on new causes of action for Bivens. Crucially, however, and this is where they completely messed up the boat, the officers raised this argument for the first time on appeal. And all the lawyers in the room go, uh-oh. At no point during the lengthy proceedings in the district court did the officers argue or even suggest that Hicks lacked a cause of action under Bivens. Uh-oh. We thus conclude this argument is forfeited on appeal. So, yeah, basically, this is a legal fail. This is, once again, a legal fail. The attorneys screwed up. They are saying on appeal, this should have never happened. This isn't Bivens, and the Supreme Court has repeatedly refused to extend Bivens. So this should have been dismissed. And the Court of Appeals said, might have been nice if you had mentioned that before. Never brought that up, so, sucks to be you. Yep. The officers do not dispute any of this long-standing doctrine, which is good because, that's not going to work if you tried. Instead, they argue, in effect, that the doctrine does not apply here. This should be real good because the error of which they complain is non-waivable. So they say, we might have never brought it up, but we didn't have to bring it up. It's available to be brought up at any time, even on appeal. We can just mention it. It's non-waivable. Okay. According to the officers, Abbasi sets out a framework that now must be applied in determining whether a Bivens remedy is available against a federal official, under which the courts first must inquire whether a given case presents a new Bivens context, and if it does, it then must Before extending Bivens liability, evaluate whether there are special factors, counseling hesitation. And because the Abbasi analysis is mandatory, the officers argue, the district courts are obliged to take up the question sua sponte, even if the defendants do not raise it. Okay, yeah, every lawyer in the room knows that these guys are in serious trouble. Every lawyer in the room knows these guys are in serious trouble. Yeah, this is non-waivable. The court has to do this, and the court should have done it on its own motion, even if no one brought it up. Now, I suppose the court could have done it on its own motion, because the court can do a whole ton of shit under its own motion, because courts have a shit ton of power. So I guess the court could have done that, but they had to. They were required to bring it up themselves. And that doesn't sound like that's going to work. We disagree. No joke. As a general rule, the parties' litigation conduct determines what issues are properly before a court, and a defense may be forfeited if the party asserting it waits too long to raise the point. There's an exception for rules governing subject matter jurisdiction, which may be raised by a party at any time or by a court on its own initiative. But the availability of Bivens cause of action does not fall within the exception because it's not an issue that implicates a court's subject matter jurisdiction. So this exception to non-waivability is tried and true. And it's basically the only issue that is non-waivable. Because if a court doesn't have subject matter jurisdiction, then everything they did was invalid from the first instance, because they literally didn't have the ability to hear the case. So as long as you bring it up any point before the case is final, and once it's final, you might have another set of problems, you can bring it up at any time. In fact, you can bring it up for the first time at the Supreme Court. In fact, the Supreme Court can bring it up for the first time at the Supreme Court. I've actually seen that happen. I've actually seen the U.S. Supreme Court raise the issue of subject matter jurisdiction themselves, sua sponte, for the first time, and then say, we don't have jurisdiction. No one thought to mention it. No one thought to rule on it. But yeah, this is one of those things that courts can and must do, is subject matter jurisdiction. And so they say, this is subject matter jurisdiction. And the Court of Appeals just pats them on the head and be like, that's nice. That's a nice idea. Good try. No, it's not subject matter jurisdiction. No. The court does have the power to hear this kind of case. So, no. We now turn to the officer's challenge to the district court's ruling on qualified immunity. We conclude that we lack jurisdiction to consider this portion of the officer's appeal. We lack jurisdiction to consider something. How could that possibly be? How does the Court of Appeals lack jurisdiction? Because the officers contest only the district court's assessment of the factual record and raise no reviewable questions of law. Just wow. Just all the wow. All the wow. Now, I guess you could understand kind of a lawyer screwing up the Bivens thing, because it doesn't come up a whole lot. There's not a lot of Bivens case law. So, could you give the lawyers a bye without saying it's a malpractice for screwing up the Bivens thing? I guess. I mean, they probably should have known that. It's probably a fail, but if we're feeling really, really generous today, we can give the lawyers a bye for the Bivens thing. Bivens comes up so rarely that maybe it's okay they screwed it up, or at least we can understand it. In this case, however, they appealed based on facts. Apparently, they have no problem with the law. They just think the district court screwed up the facts. I don't have any problems with the law, Court of Appeals. I just have a problem with the district court's determination of the facts. I'd like to appeal the facts now. We emphasize at the outset what the officers are not challenging on appeal. Tell us what they're not challenging. They do not argue that if we take the facts as the district court gave them to us, then the district court erred as a legal matter when it found the alleged conduct violated the Fourth Amendment. Okay? So the officers do not contest that if you take the facts as the district court found, they would be violating the Fourth Amendment. You get that? They do not contest that if you take the facts as true, they are liable under the Fourth Amendment. Okay. Because the officers unreasonably extended the first stop and conducted an immediate stop without sufficient justification. They have no problem with the conclusion given the predicate facts, nor the officers take issue with the second step of the district court's qualified immunity analysis, arguing that any Fourth Amendment violation they may have committed was not clearly established at the time of the incident. Do you understand this? Are you fully comprehending the words of this? They are not arguing that they are not arguing that either A, they violated the Constitution, or B, that it was clearly established at the time. They are not contesting that they violated the Fourth Amendment and the violation was clearly established at the time. Okay. You do you, I guess. Instead, the officers seek review of a question that we may not consider in this interlocutory posture, whether the district court properly assessed the factual record. Okay, this is a interlocutory appeal. Interlocutory appeals are limited. The interlocutory appeal in this question is the denial of qualified immunity. The district court denied qualified immunity. And so they want to go to the Court of Appeals to fight that determination. And they think the determination is wrong because the district court screwed up the facts. We have no problem just admitting that we violated the Fourth Amendment and that was clearly established. We're just really grumpy with the factual determinations from the district court. The same is true of the second stop, as to which the officers, again, exclusively raise fact-based arguments. Facts! Here the officers' focus is on the district court's determination that the factual record read in the light most favorable to Hicks and resolving all material factual disputes in his favor, which is exactly what the district court is supposed to do, show that Officer Phillips left the scene of the first stop just after Hicks and recognized Hicks' car before he pulled it over, and Hicks was not driving erratically at the time. According to the officers, the district court erred in its assessment of the record, and you're going to really love this part, guys. This might be the best part. The district court erred in its assessment of the record by disregarding Phillips' own deposition testimony to the contrary. Okay. There's not enough wall for me to beat my head against. Phillips is the park police guy, right? Being sued by Hicks. Hicks says, here's a whole bunch of things that happened. And Phillips says, that's not fair. You didn't take into consideration my deposition. What? Okay. I know this is really hard. So let's just go back to square one on this one. All right. Okay. Let's just go back to square one. Okay. Qualified immunity is a defense. It comes in the form of a motion to dismiss. That's how you raise the issue, along with any other motions you might have, right? What are your defenses? Well, one of them is, I have qualified immunity. Great. So you're moving to dismiss because you think you have qualified immunity. Great. By law, we look at the facts from the position of the non-moving party. Which means by law, all that matters is what Hicks has to say, unless it's palpably insane. So if it has any sort of colorable validity to it, we assume it's true. That's how this works. Phillips is moving to dismiss. Therefore, we assume everything Hicks says is true. And Phillips says, that's not fair. You didn't consider my deposition. What? I mean, just all the what? What? This doesn't... I don't even know where to start. I'm having a stroke just thinking about it. We better move on. For the foregoing reasons, we dismiss the appeal in part and otherwise affirm the district court's order denying the summary judgment. Thus, that brings us to the end of our discussion from the Fourth Circuit case of Nathaniel Hicks versus Ferreira and Phillips. In this case, Hicks was a Secret Service agent sitting by the side of the road getting ready to leave a caravan, and the park police, who have an amazing bug up their ass for some reason that is not clear in the record, pull this guy over twice, detain him at length, even though they were able to establish that he was a police officer. And he says, and Hicks says, here's a whole bunch of things that happened. Here's what happened. They pulled me over, they took my badge, they were able to determine who I was, and they overextended my stay by about 40 minutes. And then, when they pulled me over the second time, he recognized my car, and he still held me over and detained me. And then Phillips over here, genius to the cause, says, oh, that's not fair because I contest those facts. You didn't read my deposition. I have no problem with the legal determination. I just have problems with how the district court construed the facts, because they construed the facts without reading or considering my deposition and crediting everything Hicks said. I don't know what to tell you. It's just a pile of stupid. It's a pile of stupid, and that, for the moment, brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye. Yeah. This is not hard.